once more, and I feel honored and privileged to be part of this process. And I wish that when I was in school as a young lawyer, somebody had introduced this kind of conversations. But here we are. It has been a long journey. And when we are talking about judicial interpretations and legal framework on gender, reproductive rights, and sexual minorities, it has been several steps incrementally, but very powerful. And as the previous speaker has said, at the core of the entire conversation, and I hope for the entire Moot Court competition, the issues should remain about justice, about equality, about non-discrimination, and respect for the rule of law for all persons, including sexual and gender minorities, and also part of the reproductive health rights. When we talk about judicial interpretations, we look okay. We look at the Constitution of Kenya, which provides a progressive foundation for human rights.
Please, let's mute the mic. To mute the mic, please. The ground rules of the House. Let's maintain that. Speak through the chair, speak through the speaker, tafadhali. If your mic is on, please mute. Yes, Ms. Mbaru, please proceed.
Thank you. Thank you. We look at the Kenyan Constitution, which provides a progressive foundation for human rights, including non-discrimination, equality under Article 27, right to dignity, Article 28, and also Article 43 on right to health. These provisions form the basis for interpreting gender and reproductive health. However, for gender and sexual minorities, including persons who are gay, lesbians, and the entire domain of transgender persons, intersex persons, judicial interpretations has often navigated a very complex terrain between constitutional promises and societal conversations and conservationism, where people strictly go back to their societal and cultural cocoons and want to conserve things that ordinarily are not lawful or are not protected under the Constitution. But how did we find ourselves here? I would like to digress and go back to 1994 when South Africa transitions from apartheid democracy. And under the 1996 Constitution, they included a word called sexual orientation. And everybody in Africa, AU member states, were appalled by South Africa. But we dismissed them and said, let those ones, they don't know what democracy is all about. They have suffered enough under apartheid. So maybe they borrowed a lot from the white community. And it became like South Africa was the Lone Ranger in the entire continent that had a progressive constitution that included persons because they included provisions of non-discrimination against anyone, including on sexual orientation. Come the year 2006, in Uganda, we had the case of Victor Mukasa and Yvonne Oyo, who were violated in terms of their right to privacy, and they went to court. And the painful journey of the two was largely because the judges who were hearing that petition could not even mention the word segmentation. The lawyers were very apprehensive when they were drafting the pleadings not to include words that would make the judges sort of send them away from court. Writing the judgment in that case took quite a while, not 1 year, not 2 years, back and forth. And behind the scenes, trying to discuss with the judges. At that time, I was not a judge yet. I did not know I would be a judge eventually, but here we are. But having conversations behind the scenes, the judges were conflicted. Do we use these words? Do we apply terms that are not acceptable in our society? We are so religious, we are so cultural. So do we use the word gay or lesbian? Because Victor Mukasa and Yvonne Oyo were openly gay persons. But the judges would not want to use those words. The lawyers were afraid of using those words in court. So the judges were not comfortable. And when you read that judgment from Uganda, there is no word applied referring to LGBTQ plus at all, none at all. Come to Kenya, and we had the case of Richard Mwasia and the judges of the High Court, a bench of 3. Again, we go back to similar contexts like Uganda, and the judges were categorical that we can understand Richard Mwasia because for him, he's an intersex person. That is biological. But for any other person who describes themselves as being gay or lesbian, those are matters of choice. So the 3 High Court judges, in a unanimous judgment, no dissent at all, they were like, no, we are doing our society very well by making this pronouncement that they are matters of choice, but also they are biological matters. But again, as I said, constitutions are evolving, law is evolving, but it depends on how you apply the law. So you go to school as a law student, and the reason why I'm happy today by the progress that I hear, the conversations that are likely to happen within this Moot Court competition is when you learn law in school, it will remain law on the books or in the books. But out here, how do you take that law and translate it to reality? How do you apply that law to everyday realities of community members? How do you take that law and make it an item for justice, make it a tool to take and demand for equality, take the law, change society to ensure non-discrimination, but also take the law back to the people and ensure respect for the rule of law for everyone, including LGBTQ plus persons, and also for sexual rights. How do you use the tools that you're learning right now in school to empower the community and yourself? I believe we should start the other way around. Empower yourself first and then empower the community so that whatever else happens after you leave law school, it is a tool for advocacy. You don't go to school and just leave with good marks. You go to school as a changed person, empowered to go out there and ensure justice, equality, and discrimination, and respect for the rule of law. And the terrain, as I have described, from South Africa to Uganda to other parts of Africa, it has not been easy. Even for Kenya getting the 2010 constitution, the word sexual orientation or gender identity was not applied. But again, we come from a Commonwealth jurisprudence and jurisdiction where once there is a pronouncement in court, that pronouncement is applied as judge-made law. What members of parliament are not able to do in formulating the law, that can be taken by the lawyers, the advocates, activists, now allowed under the Constitution, under Article 22 and 289, to come to court as friends of the community, friends of the society, democratic, free-spirited persons, and urge and advocate for the rights of persons who ordinarily would not be able to speak for themselves. Or because of how they are placed, they are not able to urge or advocate for their rights. And the landmark case and the pronouncement of the Supreme Court in the case of the NGO Coordination Board and versus EG and 4 others, and Katiba Institute was the amicus, comes to fore on a journey that has taken many steps from Richard Moasia going to BBA at the High Court. And what interested me a lot in the Supreme Court judgment was not even the main judgment itself, the final pronouncement, was about the dissenting 2 judges, the 2 judges who disagreed with the others. And for the Moot Court competition, I hope the students, you go back when you're making your arguments, read why the 2 judges dissented. Largely, society has not yet accepted these kind of practices. A conversation, I believe, these practices about them and us. We are the good ones, they are the bad ones. So it will be interesting to hear how the arguments in the Moot Court competition is all about. So read those 2 dissenting judgments. But again, but again, at the end of the day, pronouncement to allow discrimination based on sexual orientation would be to counter the constitutional principles, and therefore the action of refusing to reserve the name of the intended NGO by the respondents in the Supreme Court case, that is EG and 4 others, was found to be unconstitutional. That pronouncement is very, very phenomenal, foundational, and that pronouncement by the highest court of the land is to be celebrated. And as I said, it has not always been like that. We witnessed the case of Republic versus Collins Otieno, a criminal case, an openly gay person in Eldoret, an activist, an advocate, out on his own business, thriving and celebrated in many platforms, was murdered. And the accused person, when he testified in court, the court was very categorical that despite his spirited defense, the murder of the activist was found to be based on the sexual orientation, idea of extortion and blackmail. You have been having a relationship, but they keep on extorting from you. They keep on blackmailing you that unless either you give me so much or you accommodate me in this and this way, I will out you. But again, the victim was already openly out and gay, but he went ahead and murdered him. And Collins Otieno has now received a sentence of 30 years in jail. And the judge of the High Court, when sentencing him, said that the offense was motivated by, or there was demonstrated hostility to the victim based on his sexual orientation, and that was found to be unconstitutional. So even in a criminal case, when it is advocated based on the principles of the Constitution, justice, equality, non-discrimination, and rule of law, you will not go out and violate a person's rights because of their sexual orientation or gender identity, and then go away with it and say, no, I feared he might attack me and violate my rights. No, the rights of everyone are to be respected. The rule of law is there for everyone. And then also in the case of COL and another versus resident magistrate, Kwale Court and 4 others, again, the rights to privacy. When the police decide to invade your house, your private space, carry documents, carry your property, and then purport to assert that you're a criminal, and the property that they have collected, maybe the moderator can control the background noise. Okay, thank you. Thank you. So in that case, the High Court judge who was dealing with the matter of COL and another, and against the resident magistrate Kwale Court, was, I believe, conflicted in terms of, do I apply the Constitution progressively or do I appease the society? And the High Court judge was, no, these are criminals. They need to go to the hospital, subject themselves freely, voluntarily to annual examination, so that the matter before the magistrate's court in Kwale can proceed against them. But again, when you look at the courts being used by police officers to violate somebody's privacy and ordering somebody to subject themselves voluntarily so that evidence can be obtained from them, using scientific evidence obtained from you illegally for a matter against you. No, the matter went to the Court of Appeal, and the bench of 5 judges at the Court of Appeal said the High Court judge made an error of allowing somebody's rights to be violated so that they can be able to subject to a criminal trial at Kwale Law Courts. And the Court of Appeal terminated those proceedings and ordered that the accused persons before Kwale Law Courts should be awarded compensation. So we have had a mix of litigation over time. In the case of Republic versus Kenya National Examination Council and Audrey Mbugua, again, the High Court ruled in favor of transgender persons' right to have academic documents reflect their true identity. Very phenomenal. This case set a legal precedent on recognition of gender identity grounded on the right to dignity and non-discrimination. Again, in the case of Baby A versus the Attorney General, it concerned itself with the case of an intersex child who was denied legal identity. And the court acknowledged that the state's failure to provide a legal framework was a violation of rights, and called for legal reforms that reinforce children, reproductive, and identity rights. You can imagine a child born and the doctors or the midwives cannot clearly set that child out into society in a manner that that child can be properly identified. The conflict between the parents and society. But again, this case of Baby A was foundational in setting out that a child who is born intersex has a right to live and able to enjoy their sexuality until they are of age of majority and can decide for themselves how they want to live. So that child should not be denied their right to identity simply because they've been born as intersex. The case of National Gay and Lesbian Human Rights Commission and the NGO Coordination Board again escalated up to the Supreme Court. And these are some of the incremental steps that I believe the Moot Courters will be able to work around and see how the courts have been able to start from a very, very conservative terrain, but progressively guided now by the Supreme Court, which binds all the other courts in the land. We are now guided on how to interpret and apply the law in terms of the constitutional framework. Whatever your religious orientation, whatever your cultural dynamics, or whatever your values, the constitutional morality should apply, just like what happened in India. So in terms of policy and legal frameworks, consider the Constitution under Article 27, Article 28, but again, don't forget Article 43 on the right to health. The Penal Code, again, sections 162 up to 165 have been problematic, where they criminalize same-sex relations, creating a conflict between constitutional rights and outdated laws. But when we are guided by the constitutional morality, then even the Penal Code, when matters come to that, sections 162 up to 165, then we target the constitutional morality. The Children's Act, which has now been revised, offers some protection for intersex children, but again, it lacks a comprehensive provision for gender diverse children and minors. The Health Act, it also recognizes reproductive health rights, but does not specifically address the needs of gender and sexual minorities. There are also the National Guidelines on Adolescent Sexual Reproductive Health, which provide a framework for youth reproductive rights, but it remains silent on the rights of LGBTQ plus inclusion. So these are gaps that legal practitioners, advocates, activists can take forward applying the constitutional framework. But again, Kenya now, current constitution, we are bound by international instruments. When you look at the Universal Declaration of Human Rights, it covers everyone, and the rights therein cover all Kenyans, including the LGBTQ plus persons. The African Charter on Human and People's Rights, also framed under the African values, which are very, very conservative. But again, at the domestic level, we are covered under our constitution. When you look at the Maputo Protocol, which explicitly protects women's sexual and reproductive health rights, it offers a basis for inclusive judicial interpretations. So when you're coming to court seeking to enforce, to assert the rights on reproductive health or the rights of sexual minorities, you can use these as the tools to persuade the judges, the magistrates to interpret the law in a progressive manner under the template of Article 2(6) of our Constitution. And before I conclude, we are still facing challenges because of serious contradictions which remain between progressive constitutional provisions and criminal laws on same-sex conduct. So even as we have the Constitution from 2010, 15 years later, we celebrate the 15th birthday shortly in a week's time, but still we have criminal laws, the Penal Code, sections 162 to 165, not reflecting the constitutional morality. So there's still some work to be done. There are also limited judicial engagements with the specific reproductive health needs of transgender and intersex persons. Let us litigate. The feedback, the returns we get from court, they only serve to amplify the rights of persons in communities. So let us not hold back from the few cases that has been dismissed. Let us litigate, go to court with cases that the judges will be allowed to interpret the Constitution in a progressive manner. And for me, every setback that you get in court is an opportunity. Opportunities exist for strategic litigation, access to gender-affirming care, legal recognition, and protection from discrimination. Take every loss, take every setback, every bad comment made against you in court, in community, by our leaders as an opportunity, and take it head on. Use the constitutional morality. Judicial interpretations in Kenya have been incrementally progressive, in my view, recognizing certain rights of gender and sexual minorities through landmark cases. However, systemic legal and policy gaps persist. We need to identify them and tackle them head on. The courts can play a transformative role by harmonizing domestic laws with constitutional mandates and international human rights obligations, thereby safeguarding the right to dignity, equality, and reproductive autonomy of all Kenyans. Going forward, the judiciary must adopt a more transformative approach that centers on constitutional values, the dignity of the person, equality of all people, and the right to. By fully embracing international human rights norms and resisting the pressure of conservative backlash, the courts can solidify their role as protectors of all Kenyans' rights, regardless of gender identity and sexual orientation. I thank you most sincerely.